afternoon, everyone. Uh, Please welcome Shri Rajeev Bali, sir. He is a senior district judge and presently serving as director of Himachal Pradesh Judicial Academy. He did LLB from Himachal Pradesh University. Thereafter, he practiced in the Civil, Criminal and Revenue Court at Solan. He was selected as a public prosecutor in the year 1998, and then he was selected in Himachal Pradesh Judicial Services. Today, he will be presenting on courts, law in action and judgment writing. Thank you, sir. Please listen.
Thank you very much. I deem it a matter of pride, privilege and prayer for having been invited to address such an elite gathering in the capacity building program on exploring the dimensions of search methods in social sciences and jurisprudence, being organized by Himachal Pradesh National Law University. I am also thankful to Professor Chanchal and Dr. Vijay. They have really put me to task. Let me tell you very frankly, judges are not very good auditors. They speak through their judgments. So bear with me. I am not that much good auditor to especially to address such a scholastic gathering. As you all know that India is the most ancient nation which has evolved and developed the oldest legal and judicial system in the world. India has a recorded legal history starting from the Vedic ages, and some sort of civil law system may have been in place during the Bronze Age as well as in Indus Valley civilization. Starting from Samritis, administration of justice was, according to Samritis, one of the most important and obligatory function of the king. King was the supreme. So here we relate the king to courts, and wherever we refer dharma, that is law. The Samritis stressed that very object which the institution of kingship was conceived and brought into existence was of enforcement of dharma. The main function of the king was to enforce law, was to enforce dharma. How it was enforced by use of might of the king and to punish the individuals for contravention of dharma. The Samritis greatly emphasized that it was the responsibility of the king to protect the people. The similar responsibility is on the courts nowadays to protect the legal rights of the people, especially fundamental rights. And they used to protect it through proper and impartial administration of justice. As we all know that society evolved gradually and probably very slow. From society to state, the traveling was very slow. So also about the institution of governance, including legal system, and its main branch is courts. So the court system which we are seeing today, it developed gradually and at a very slow pace. Coming to the Indian context, society being primitive and largely agrarian. So what was their requirement? Simply peace and tranquility to grow. As such, a set of norms to which individual had to conform originated. So as per their requirements, the law evolved. So in the beginning, adjudicatory bodies were mostly presided by elders or the wise men of the village. Similar pattern is being followed nowadays also in the panchayat courts. These are being presided by the president of the panchayat. And mostly the society is again agrarian, so they serve the needs of that society. And king was also not supreme. He was also subject to dharma. If the king is doing any wrong, he was also liable to be punished. You must have heard about this Upanishad. The Dharana Upanishad has clearly defined what is dharma. As I have already told you, that dharma is law. Dharma is the king, and there is nothing beyond it, as it enables the weak to prevail over the mighty. The purpose of the constitution is also the same. The directive principle of state policies, it defines how to prevail over, how to help the weaker section, how to prevail over the mighty. So these things are borrowed in our constitution from this Upanishad only. The concept of rule of law is that the society must be governed by law. If law is not there, there will be a chaos, and you can imagine what kind of society that would be. The law has been built in this country from ancient times. The necessity of scrupulous practice of dharma is forcibly expressed by men. Dharmo avhato hanti dharmo rakshti rakshta. Tasmat dharmo na hantavyo mano dharma athovati. Means dharma protects those who protect it. Those who destroy dharma get destroyed. Therefore, dharma should not be destroyed, so that we may not be destroyed as consequence thereof. So if you go through it, the entire judicial system, rather executive also revolves around this. So it is our prime duty that we have to protect dharma. Manu wants that do not destroy dharma so that you may not be destroyed. A state of dharma was required to be always maintained for peaceful coexistence and prosperity. So these are interlinked. If we protect dharma, dharma will protect us. If we protect law, law will protect us. The Kautilya too propagated this principle, which was already established in the age of Ramayana. Rama, the king of Ayodhya, was compelled to manage his queen, whom he loved and in whose chastity he had full faith. But only because of the subject dispute of his having been taken back, a wife who had spent a year in the house of her abductor. Though the king Rama submitted to the will of the people, but inside he was heartbroken. So for the, whatever pleases his public, he considered it good. According to Jurisprudence Smriti, there was hierarchy of courts in ancient India also, beginning with the family courts and ending with the king. So elders of the family, they were the best mediators at that time also. So similar pattern of mediation which we are following nowadays. So all the disputes, whether big or small, these were being sorted out by the elders of the family. The lowest was the family arbitrator. As I told you, the mediation was being tried by them. They used to act as arbitrators. The next higher court was that of judge. And thereafter Chief Justice, who was called Pradaviveka or Adhyaksha. And at the top was the King's Court. Regarding jurisdiction of these courts, that is to be decided as per the importance of the dispute. The minor dispute being decided by the lower courts and the most important by the king. And the same pattern is being followed by us even today. Ancient Indian jurists, they gave great attention to the evolving of law governing the administration of justice. Emphasis was also laid on the location of the court as well as the qualification of the judges. Now you can also very well imagine that high courts are generally situated in the capital cities. Even at that time they visualized that the court should be located at the capital. Qualification of judges are also prescribed today. Even at that time also there was qualification of the judges. The highest court to be located at the capital city, appointment of experts as assessor to assist the court on technical questions whenever it was necessary. Now you can imagine that forensic experts, they aid to the court in DNA matters or in cybercrime matters. Even at that time the law was so much evolved that there were experts who used to assist the courts. Law, prudent procedure and evidence was being followed at that time also. Regarding the role of judges in the Smritis, first thing was fearlessness, secondly impartiality, and thirdly independence on their part. The fact that ancient law writers were bold enough to incorporate many provisions that no king dared to question the authority of the Smriti writers who incorporated such provisions in the Smritis. Two of the most eminent writers, Kautilya and Madhva, they were the prime ministers of Magadha Empire and Vijayanagara empires. They also proved that these provisions laid down in the Smritis about the independence of the judiciary and the supremacy of Dharma. And that is binding on the king also. And these were never questioned, even by the king also. How the law received its sanction? The law received its sanction from the faith of the people and the king in Dharma. Thus, the Smritis had laid down a firm foundation for an independent judiciary to ensure dharmic supremacy, where the king was the head of the state under the monarchical system. These standards have not been surpassed till now. We are still following these regarding the independence of the judiciary, supremacy of the judiciary, fearlessness of the judges, impartiality of the judges. These things are still in existence. Before proceeding to the gradation of the courts in the ancient time, I would like to give a very small illustration or rather example of Peshwas. Rama Shastri was the Chief Justice of the Peshwas in Maharashtra. And in 1774 AD, it indicated the assertion of the sanction of Dharma and the supremacy of the judiciary. After the death of Peshwa Madhavrao in the year 1772, his surviving younger brother Narayana Rao was to sit on the throne. But his uncle, Raghunath Rao, he was very ambitious and he wanted to grab that throne. So as a result of this conspiracy, young Narayana Rao, who was just 17 years of age, was murdered in the year 1774. Rama Shastri, who was the Chief Justice of Peshwas, he probed into the murder of Narayana Rao and he held the accused Raghunath Rao, who was sitting as a king, and 49 others, including one woman, guilty of murder and convicted them for the offences. This decision was communicated to the ruler, Peshwa Raghunath Rao. As it was prevalent at that time that a quantum of sentence was to be decided by the king, not by the Chief Justice. He can only held guilty, but for quantum of sentence, the matter was being referred to the king. So when the matter was referred to the king by Rama Shastri, the Chief Justice, to decide the quantum of penalty, the Peshwa took no action. He kept mum. And ultimately, when the Chief Justice insisted on his decision to be given effect, the Chief Justice was thrown out. So he left Peshwas. And as a consequence, this Ranaut Rao dismissed Ramasasi, the Chief Justice, and he left Peshwas. But what happened? Dharma asserted its supremacy through people. The people who heard that the decision was given by Justice Ramasasi, so they asserted that king should be punished. I want to highlight that the supremacy of law is also there through people. It is not only the courts which highlighted the supremacy, but the people of that time also highlighted the supremacy. What people did, they refused to recognize Raghunath Rai as Peshwa, and ultimately he was found guilty of murder of that young ruler. And thereafter he was punished, and a council of 12 persons, that is known as Bara Bhai, was formed, which took over the administration of Peshwa Empire. So this is a very illustrious example and a very inspiring one also, glowing tribute to supremacy of Dharma, the independence of judiciary, and exemplary conduct exhibited by a judge. So you can very well imagine in 1774 AD how exemplary conduct was exhibited by Chief Justice Ramasasi. At that time, the creation of courts, you all know that Kulas, gathering or family councils, Shreni, corporation, then assembly, Gana, Adhikrita, court appointed by the king, and lastly the highest court, king himself, Niripa. As we are having mobile courts in present days, at that time also there were mobile courts. A Pratishtha, it was a mobile court, and Pratishtha was a permanent court situated at a particular place. Firstly, can be classified as people's court, Kula, Shreni and Gana. Kula was nothing but it was an assembly of impartial persons belonging to a family, and they used to decide the matters. Secondly, Shreni, it is a corporation of persons following the same craft, same profession, same trade. So it was a sort of corporation. And thirdly, Gana, assembly of persons belonging to one place, similar to as Gram Panchayat of present days. It is assembly of persons belonging to a particular village. Regarding jurisdiction of these courts, Kula, Shreni and Gana could decide all the disputes except those falling under title Sahasa. What is Sahasa? Sahasa means any offense committed with violence, just as rape, hateful speeches, dacoity, forcibly dragging the property of other persons, etc. So they were competent to decide all the small matters except the serious disputes which I have mentioned as Sahasa. Further, fines and corporal punishments can only be incorporated by the king. As I told you that the judges, they were only given powers to decide, but ultimately it was the king who has to decide the fine and corporal punishment which is to be given to him. The people's court consisted of panchayat laws. Similarly, we are having panchayat courts nowadays. They had authority to decide all the civil and criminal cases, except those where the violence is used. But they had no authority to execute the sentence. The sentence, fines and corporal punishments were the ultimate authority of the king. There were also appellate jurisdiction. The Shreni can review the decisions of Kula, and similarly, Gana can review the decisions of Shreni and Kulas as appellate courts. Regarding the existence of these courts, there is also a report, that is 14th report of Law Commission of India regarding the existence of the courts. Though ancient writers also told us about the hierarchy of the courts, many writers like Narada, Brihaspati, they suggested that there should be regular courts. These courts were not regular, but these writers they suggested, and especially law commission also realized that regular courts are required for the speedy justice. Similarly, popular tribunals, just as I told you, Ula, Bireni, Kirana and Shreni, these are the village courts. Law Commission also suggested that these courts should also be there at panchayat levels. Then comes the King's Court. It was the highest court of that time, to be situated at the capital city in the royal palace. And if a party is not satisfied with the decisions of the tribunals below which I have discussed, then the king was given power to reconsider the decisions, to review the decisions of the trial to the courts, and it was having the appellate jurisdiction. And similarly, this part of the sovereign power is comparable to Article 136 of the Constitution, where the Supreme Court has been conferred with these powers. The second part of the discussion, I will briefly touch it. That is law in action. What is the present scenario? The present scenario is very much visible. Yesterday, 3 bills have been passed regarding Bharatiya Nyaya Sanhita, Bharatiya Sakshya, and Bharatiya Nagrik Suraksha, IBC, CRPC, and Indian Defence. So it shows that law is always in action. It is being evolved and developed as per the requirement of the society. The redundant provisions they have been left out and new provisions have been added. In very heinous offences such as rape with a minor, there is a capital punishment now. Mob lynching is provided with capital punishment. So law in action is associated with legal realism that examines the rule of law, not just as it exists in the states, statutes and cases, but as it is actually applied in the society. So what is the need of the society? The law is accordingly evolved. There was need of domestic violence, so the law was evolved, protection of women from domestic violence. So as per the need of the society, the law evolves, and this is what the law in action. Kenneth P. Davis, in a very simple words, he has exemplified law in action. Means that in teaching and research, no matter how interesting we find a legal theory, but we always need to ask, how does this affect people's lives in the real world? Whenever any law is evolved, it may be very interesting in discussions in legal theory, but how is it affected the lives of the people? That is very important. So in a very simple manner, he has described law in action. Secular law in India varied widely from region to region, from rural to rural. Court system for civil and criminal matters were essential features of many unique dynasties of ancient India. Excellent secular court system existed in the times of Mauryans and Mughals, with the later giving way to common law system. Coming to the importance of the judiciary, as I have already discussed, that Supreme Court of India is in fact one of the most powerful courts in the world. Right from 1950, the judiciary has played an important role in interpreting and protecting the Constitution. In ancient society, in any society, disputes are bound to rise between the individuals, between groups, between individuals or groups, and government. All such disputes requires redressal by an independent body in accordance with the set procedure of law. This idea of rule of law implies that all individuals, rich or poor, men or women, backward or forward, are subject to the same. The principal role of the judiciary is to protect rule of law and ensure supremacy of law. In the first part of our discussion regarding courts, we have discussed about the supremacy of dharma. So now we have transferred to supremacy of law. Dharma is nothing but it is law. What your conscience says. As India is a democratic country, the Constitution of India has provided several rights to the citizen. We always remember rights and forget about our duties. So where there is a right, there is always a corresponding duty. So we are very conscious about our rights but not of duties. Along with these rights, certain laws were set and implemented by the legal system in India. These laws may help the societies from individuals who are violating those rights. So whenever any right is violated, jurisdiction of the courts is invoked, either by way of Article 32 or in the courts in any manner. So whenever there is violation, the courts come into picture. Legal system in India consists of civil laws, common laws, customary laws, religious laws, corporate laws, family laws, if you could name, within the legal framework. After the independence, the Parliament of Independent India was with the force where a document that would guide the young nation was being crafted. It will fall on the theme of legal mind of Dr. B.R. Ambedkar to formulate a constitution for the newly independent nation. It was not an easy task. And one of the unique features of Indian Constitution is that, notwithstanding the adoption of a federal system, existence of central acts and state acts in their respective spheres has generally provided for a single integrated system of laws to administer both union as well as state laws. So in every state, it has its own law. As talking to Himachal Pradesh, it has many its own laws pertaining to land laws, excise acts, police acts, but at the same time it is also following the union laws. So there is a blending, federal structure. At the apex of entire judicial system exists the Supreme Court of India, below which are the high courts. Below the high courts lies the hierarchy of subordinate courts. Panchayat courts also function in some states under various names like Nyaya Panchayat, Panchayat Adalats, Gram Kachari, etc. to decide the civil and criminal matters. Different states laws provided different kinds of jurisdiction of courts. Each state is divided into judicial districts, presided over by a district and sessions judge, which is the principal civil court of original jurisdiction, and can try all offences, including those punishable with death. The sessions judges is the highest judicial authority in a district. Below him there are courts of civil jurisdiction known as municipal courts, civil judges, and sub-judges court. Civil and the criminal judiciary comprises the chief judicial magistrate and judicial magistrates of first and second class. Indian judiciary is divided into several levels in order to decentralize and address the matters at grassroots levels. Even in ancient India also there were courts at grassroots levels, Kulla, Shreni. So they were deciding the petty matters pertaining to the agrarian society of that time. Article 141 and 144 of the Constitution afford the authority and jurisdiction given to the Supreme Court. Article 141 lays down that all the courts and tribunals are bound by the decisions of the Supreme Court. And for the Article 144, it tells us about the contempt. If these decisions are made not being followed or violated, then there is a provision of contempt regarding the disregard or disobey of the orders. Regarding the evolving of law and courts, I have told you in the beginning about the 3 new bills which have been passed by the Lok Sabha yesterday regarding Indian Penal Code, Indian Evidence Act and Code of Criminal Procedure. Locals is also a very popular name regarding the law in action. Many cases are being referred to locals and these are becoming very popular. Once for all the matters are being disposed of in these locals. So it tells us that how the law evolved regarding the establishments of the courts from time to time. Next, I will switch over to the third and the most important part of this discussion, that is judgment writing. We all know that justice ought to be timely delivered. These bills have been introduced and passed by the Lok Sabha for timely justice and speedy justice. In many of the bills, there is a provision that after the registration of the FIR, the matter is to be disposed of by the court within 3 years. So the courts are bound to decide the matters as per new provisions which are likely to come in a time-bound manner. So justice ought to be timely delivered, but at the same time, the judgment rendered by the court, which are means of delivery of justice, should be framed in the best possible manner. So that's why the art of judgment writing came into being. There is no straight-jacket formula for judgment writing. It varies from judge to judge. 2 judges cannot give similar judgments. Bahulah's case has conceptualized judgment that a judgment should give finality. We have not to take it in narrower sense, in broader sense. What is a judgment which gives finality? So that is very important. What is judgment? Can anybody volunteer in simple words? What do you mean by judgment?
It is decision plus
Exactly.
plus reasons
Yes.
of that decision.
Anybody else? Very good. So that's the finality in the achievement. Regarding reason, it is very important, as you have pointed out. I will come to the later part. Reasoning and finality is the most important part. Any other thing which you think, what is judgment?
A finality of reasoning based upon appreciation of facts as well as evidence adduced in the court before the court by both the parties.
Very true. Means determination of a code. This determination by the court is the declaration of rights to be recognized and the remedies to be awarded to the parties upon facts found by the court or admitted by the parties in the course of proceedings. There is no static definition of judgment in the CPC. But under section 2, subclause 9, judgment means the statement given by the judge of the grounds of a decree or order. So that statement is a very difficult part. It comprises of many things: elaboration of facts, analysis of evidence, statutes and rules, as you have told, reasoning, determination, finality, all these things are required to be incorporated in the judgment. So definition which is given in the CPC is very simple. The statement given by the judge of the grounds of a decree or order. Whenever a decree or order is passed, what are the grounds? So that is reason. And very interestingly, there is no definition of judgment in CRPC. It is only in CPC, but there is no definition in CRPC. So far as the criminal law is concerned, Chapter 27 of CRPC, Section 353, prescribes various standards of judgment, including that it should be pronounced in the open. And Section 354, that it should be in the language of the court. So only these three things I could find out in Code of Criminal Procedure regarding this. Since there is no static definition, so it is very important to identify the tools that may be relevant for judgment writing. So these tools vary from person to person, maybe reasoning, determination of finality of a thing. So these are the various tools for writing judgment. It is not a science. Judgment writing is basically it is an art. It depends on the subjectivity and individual style of writer. Every judge has its style of writing judgment. You must have seen the judgments of Justice A.T. Thomas. He has a very good flair of writing judgments. Justice Sinha, Justice Rajeev, Chief Justice D.Y. Judicial. So it depends on the subjectivity and individuality. Still, despite having subjectivity and individual approach, there are certain well-recognized objective standards that must be followed while writing it. It is akin to fiction, but it should be such narrative that reader is engaged and eager to know what comes next, just like a movie. You must be very eager. It should not be like that you stop reading the judgment, it is very boring. So text should be such that a reader must be very much eager to know what is there in the end. While writing judgment, take the vantage point of how you would begin if you were telling your neighbor or a friend about a case. It should be like that. The factual narration in the judgment should be so interesting that even a person who does not know the field of law can understand it and compare you with a professional storyteller. So it is not a science, it is an art. How you tell that story, that makes a judgment. Regarding judgments and guidelines have also been given in the House Law of England, briefly stating that the finality of judgment must contain along with other formal parts. Firstly, preliminary and introductory part, to which we refer facts, what is there in the application, what is the belief which is being claimed by the party coming to the court. So the first thing is, along with other formal parts of the judgment, it is suggested two very important parts, preliminary or introductory part of the judgment. And secondly, substantive or mandatory part containing the order, the final order made by the court. Honorable Mr. Justice Sabyasachi Mukherjee, former Chief Justice of India, on the requirements of judgment, highlighted that a good judgment is reason. As you have pointed out, reason, that is very important part of a judgment. So he has said that reason is the soul and spirit of a good judgment. So what is the soul of a judgment? That is the reason. So judgment should be very well reasoned. When whatever decision you are coming to, whether it is in favor of a plaintiff or against defendant, it should be reasoned. You must support it. Whenever you are analyzing the evidence or statutes, it must be supported by your reason. So reason is the soul and spirit of a good judgment. This pattern is also being followed by many other countries. I will give you example of Supreme Court of South Africa. They have also introduced these things. Justice M. Corbett, the former Chief Justice of Supreme Court of South Africa. They also recommended structure of a judgment, that is introductory section, setting out the facts, law and the issues, applying the statutes, then relief, finally the order of the court. So many countries are following this form of judgment writing. Supreme Court of India has also given certain guidelines regarding the writing of judgments. In a very important case, Joint Commissioner of Income Tax versus Civil Leasing Industries, the Supreme Court has given guidance regarding the judgment writing. The guidelines given by the Supreme Court are not exhaustive. These are illustrative. It varies from facts to facts. So first thing which we have to keep in mind while writing a judgment, that we should not write the facts which are not there in the plaintiff. We must mention the exact facts which are there in the plaintiff. We cannot incorporate the facts at our own. There should be correlation with the applicable law and the facts. Ratio accident act should be clearly called out in the judgment. Generally, as a judge, I used to prepare a draft of the judgment. First, you prepare the draft, go through it, and then you can finalize it with the help of statutes, law, and citations which have been given by the lawyers. And when finished judgment comes out, it should be chronology, it should sustain chronology. As I told you, that concept that it is readable, continued interest, and it does not feel like parting or leaving with it in midway. So the reader must be very eager to know the complete judgment. What is the final? It should have flow and perfect sequence of events. Where many judgments have been cited, it creates confusion. So you will be off those judgments in order to avoid the confusion and to incorporate clarity in the judgment. Leading judgment should be mentioned. Latest judgment should be seen. Judgment should not be your trick. It should not be passed to impress others. Language should be very simple, very short sentences. And it should not reflect a contrived effort on the part of the author. illusions should not be there. Facts should be mentioned in such a manner that the reader tend to believe. After arguments are concluded, endeavor should be made to pronounce judgment at the earliest. Because if a judgment is kept pending for a long, it gives a wrong signal to the litigant as well as lawyers and society. So it should be pronounced immediately. Human memory is too short, sometimes it is very difficult to assimilate the facts. So within 2-3 days, it should be announced. And in new act it has been provided that judgment is to be announced within 30 days and in any manner not beyond 45 days. In new code of criminal procedure. Judgment should avoid instances which would like to agitate the public. And nothing should be reflected in the judgment which may hurt the feeling or emotions of any individuals or society. These provisions were further elaborated in another judgment by the Honorable Apex Court. I will not go through it in detail, but fundamentally it has been held that brevity should be there in the judgment. And it should not be in cryptic manner, and it should not be haste decision. So in addition to the judgment of severely leasing, these 2-3 guidelines were incorporated in this judgment. And thereafter, in Union of India versus Jayaprakash Singh, further 2-3 more things were given. That it is very important that failure to give reasons amount to denial of justice. So reasons, giving reason is a very important part, soul and spirit of the justice. It has been highlighted in this judgment. Reason should be there in a judgment. There are certain basic rules of writing a judgment. First thing is very important: reasoning, clarity, and precision. There is no need to use strange and difficult words because you are writing judgment for an illiterate person. He is not very well versed with the law. He is not knowing the difficult words. He is not literary. So always write simple words, no complex sentences. A judge cannot use his personal knowledge of facts. Whatever there is in the file, you have to incorporate only that in the judgment. And pleadings are the very important part by deciding the matter, giving reasoning. If there is any evidence coming beyond pleadings, then it cannot be looked into. Evidence beyond pleadings is not permissible. So you have to formulate your judgment as per the pleadings only. The findings should be precise and specific. There should not be any confusion about the findings. And while exercising appellate or divisional jurisdiction, the judges who are having divisional jurisdiction or appellate jurisdiction, they should stop criticizing the trial courts. And most of the judgment must have seen strictures of judges of the trial courts. That's why sometimes they are discouraged. I am telling you my experience. They are discouraged to dispose of complex matters. Only just because of such strictures. Appellate courts are there just to mend the wrongs which have been committed by the trial courts. So judges should not be worried whatever they are writing in their judgment, but it should be very well reasoned as per facts, should be specific with certainty. So it is a word of caution for the appellate courts to avoid criticism of the judgments of the trial courts. What is a good judgment? A good judgment is which readable, which is readable. When you are interested to read a judgment, that means it is good. It covers all the aspects, well reasoned. Legal analysis in a judgment. It is also popularly known as FIRAC method, FIRAC, FIRAC method, facts, issue, rule, analysis and conclusion. Regarding facts, while writing judgment, identifying material facts is very important. Sometimes a client is running in 10 pages, but material facts are only of 1 or 2 pages. So, while writing a good judgment, first of all, you have to call out the material facts which are relevant for the case, the ratio acidendi of a case. Regarding facts, there are 6 very important questions. First, what? As usual, you have to know what is the factual genesis of a dispute. The first thing is what? Second, who? Who are the parties coming to the court? Third, where? The place of the dispute occurred, and it is very relevant for deciding the jurisdiction. Fourth, when? Why when is required? It is timeline to assess the limitation. And fifth and sixth, why and how, which are more particularly relevant in criminal cases for visualizing the motive, the methodology of the crime. These are very important. So these are the 6 things regarding facts: what, who, where, when, why and how. The second part comes issues. All of you are very well aware that as per Order 25, issues are to be decided by the court, and finding is required to be done on each and every issue. Sometimes there is a club 2 or 3 issues together, and the matters are being remanded back only on this one. You have to give finding on each and every issue. Particularly in civil suits where the issues have been framed, the court shall state its finding or decision with the reasons on each issue separately. Sometimes even a single issue is sufficient to decide the controversy between the parties. Different issues may have different standards, such as prima facie, preponderance of probability, beyond reasonable doubt. So these demarcates proper standards regarding the issues. Further, issue-wise having helps the reader to understand the long judgment. When it is issue-wise, first issue is regarding jurisdiction. So even when the court is not having jurisdiction on this preliminary issue, the matter would come to an end. So it is always stressed by the Honorable Apex Court that judgment should be issue-wise. Material issues should be decided, should be taken up first regarding the limitation. If the suit is barred by limitation, no purpose for going ahead. Jurisdiction, locus standi of the parties, and all the issues should be arranged in a logical chain. The second part is third part of the facts, issues, and third is statutes, rules. The judgment should then mention the relevant statute which applies to the situation. Binding precedents must be followed. Refer to Article 141, 144. They must be followed. After statute and rules comes the most important part of the judgment, that is concluding portion of the judgment. Conclusion should play a different role than a mere summary. While summary is the concise view of all the points, conclusion binds all the arguments together and states the final outcome of the case. Conclusion should be brief. Brevity is essential for conclusion. It should not be very long. It should be precise, clear, and finality should be good. When the conclusion is exceeding more than one page, it looks like a new argument in the case. And after drawing the concluding portion of the judgment, the judge should review the entire judgment once it is complete. Coming to the language of the judgment, as I have told you that you are writing a judgment for the ordinary person. He is not a lawman person. So it should be very simple. Language should be simple, precise, plain English which enables the party to go through it, to understand the contents and subjects. You are writing a judgment who is not having any legal background. Punctuation and grammar should be there. Brevity. Reasoning should be logical, coherent, and systematically organized. And sentences in the judgment should not be very long, and it should not be very complicated. You write short sentences in a very simple manner. And prefer the active voice, not passive. Avoid double, triple negatives. Paraphrasing. Avoid emotionally charged language. Concrete language. And do not overstate all the facts. Avoid such words which might create doubt on the facts quoted. Regarding the language of judgment, you must have gone through this judgment state of Aspenball versus Anwar Ali Sarkar. In this judgment, Justice Vivian Bose has given a very simple and easy language to discuss the complex question on meaning of equality in Indian Constitution. You must go through this judgment regarding the what should be the language of it. Another example is of Haynes and Bali. Lord Denning has given a very lucid and simple relation of facts. Then sensitivity in a judgment. Judgment is to be read by many sections of the society. So its language is required to be very much clear. It should be sensitive enough to inspire public confidence. It must not belittle the woman in any manner. The language must not be belittling the woman. Judgment must avoid comments regarding prevailing social norms which has been prejudicial against the freedom of a woman. Language should be gender neutral. Gender sensitive lexicon debate is going on. So law should be gender sensitive and language of the judgment should gender neutral. It should be fair and not biased. By reading a judgment, sometimes you can gather that it is going to be biased. So language should be such that it should appear to be fair. Before parting with the discussion, I would like to give one example of historical reference of judgments. These were called Jayapatra at that time. We call it judgments now. At that time it was Jayapatra. Though unfortunately system of maintaining the old judgments is not very good. Some of the judgments have been traced. These have been maintained but not properly preserved. So there is some chronicle history of judgments which we can find citing of cases in Rajasthan by Kalhan. I could lay hands on a very good judgment. It was in Sanskrit, though I don't know Sanskrit, but it was an article written by Shri K.P. Jaiswal. It is in Indian Law Reports 24 Calcutta 1990-20, 1920, written by Shri K.P. Jaiswal regarding a judgment which was delivered by a court of Mithila in 1794. The judgment was in Sanskrit. And this judgment was delivered by the Chief Justice Sacha Mishra and 7 judges. And interesting part is that it is regarding the ownership of a slave girl. And the 7 judges, they expressed their concurrence with the judgment which was proposed by Chief Justice Sacha Mishra. Regarding this judgment, reference is here in Legal and Constitutional History, Legal and Constitutional History of India by Justice M. Ramadas. You must read this book regarding the legal and constitutional history of India. So in this book, there is reference of this judgment which was in Sanskrit, delivered in 1794, and Sanskrit text of this judgment is also available. So this judgment, on reading of this judgment, it can be safely inferred that even at that time, India did not fall short of the prescribed requirement which we have discussed, but should be there in the judgment, clarity of facts, reasoning. It shows that how excellent procedural law was being followed even at that time, in the ancient times. Finally, to conclude judgment writing, I must tell you that it is an art which requires delicate weaving of legal expertise with eloquence, precision, and fairness. The best judgments are those which clearly state the legal principles on which they are based. So in process of reaching a decision, decisions are very properly read and studied as evidence of the law, but they should be used for the purpose of correcting the law from them. As a judgment has a significant social and civil function, so equity, justice, and good conscience are the hallmark of it. So with these words, I thank you very much for patient hearing.
Any questions?
Sir, I don't know whether it's a question or observation. Sir, we discussed the content of judgment. Sir, but according to me, one thing is missing, and I may know the answer. The thing is that why it is not written that judgment must reflect the truth.
Very true. When you are writing a judgment, what is truth in your? What do you think? What is truth?
Sir, even I don't know the truth. The point may be that the judgment is only based on the facts and the arguments.
Yes.
So can we
What
say that?
are the facts mentioned in the claim? You have to believe those facts. And I have told you that you cannot incorporate your own knowledge in the judgment.
Yes.
Whether these facts are true or not.
So that was my observation actually.
The judges only deliver judgments. It is my own inference. They only deliver judgments on the basis of facts, issues, statutes, laws, analysis and conclusion. He gives judgment only on these bases. So that is only judgment. But I don't call it a justice. This is the answer of your query. So whatever there is on the file, they have to believe it to be true. Though we do know that somewhere it is not true. But we have to deliver the judgment only on the facts, only on the basis of evidence, only on the basis of law. So that is only judgment, not a justice. So there is a basic difference between a judgment and a justice.
Thank you, sir.
सर हम लोग कोई रिसर्च मेथड फॉलो करते हैं जजमेंट डिफरेंस वाले?
In fact, there is no research method. Only guidelines are given, and these guidelines are not exhaustive. Self illustration. These guidelines are only illustrative. And from case to case, these vary. From judge to judge, these varies. My average is different. So that's why there is no typical theory or no particular theory to assess the judging. It varies from judge to judge, from case to case. So there is no straight jacket formula regarding that.
Thank you, sir, for your time. And on that note, we come to a close of this session. We'll assemble for the next session at 2. So, thank you.
Thank you very much.